Matt Taibbi is getting Westfalled. And if you don't remember how this story started, we're going to start with politicians being politicians, but more specifically, Democrats being demons who abuse of the pulpit to defame their political ideological adversaries. You remember when Matt Taibbi was before Congress, it was Senate hearings or congressional hearings, and I'm fairly certain it was in the context of the Twitter files, which his reporting on which his reporting was magnificent. A certain Democrat politician, her name is Rep. Camilla Ordover, called him a serial sexual harasser. I'm going to play it uninterrupted so that you can appreciate what they put him through, what he has had to go through. He sued them, and spoiler alert, he just got Westfalled, at least for the time being.
Majority is relitigating a made-up conspiracy theory about a part of the State Department that no longer exists to distract from the dumpster fire foreign policy this administration is pursuing and elevating a serial sexual harasser as their star witness in the process. Mr. Chair, I request unanimous consent to enter into the record two articles about the Republican witness Matt Taibbi. The first is a Chicago Reader article entitled 20 Years Ago in Moscow, Matt Taibbi was a misogynist a-hole and possibly worse, and a Washington Post article titled The Two Expat Bros Who Terrorized Women Correspondents in Moscow. This hearing could not be more out of touch with the concerns of everyday Americans. People's retirement savings are being decimated as Trump's arbitrary temper tariffs tank the stock market.
I have to pause it there. I can't even let that linger. What this Itchbay, who is dressed like the Joker for some reason, is referring to is a satirical piece that Taibbi and someone else wrote back in the day, which was not real, about their behavior in, I forget where it was. It was sort of supposed to be, from what I understand, like a Hunter S. Thompson-esque type satirical when bad boys behave badly. And people took it literally, which is probably the problem when you make something that's not clearly satirical or identify it as such. But they've used that as the basis to smear Taibbi, as though what they wrote in that satirical piece was true and accurate, if you didn't know.
They are staring down the barrel of cuts to their Social Security and Medicare because the Republican majority wants to give a tax break to billionaires like Elon Musk, who have deep financial ties to our adversaries. Meanwhile, Trump is siding with Putin against our national security interests and risking the lives of American soldiers in a Signal group chat. I've been to the State Department, and I do have concerns about censorship of the employees who are terrified to say the wrong thing, to say anything, or have the wrong word in their job title and be terminated by an administration that publicly relishes punishing people for their speech. If we want to talk about censorship, we should begin with Trump's unprecedented assault on the First Amendment and rule of law.
Where was the part of the beginning here? Whatever. Chat saying like, I beat you to the joke. It's not even only the Joker. There's another one, like something out of a Dr. Seuss book. That is the genesis of the defamation. Who put this post up back in the day? It was, I'm not reading the whole thing, but Petunis World. I'll give everybody the link. Seems like she doesn't have enough of a following as deserved for doing good work on Twitter. He sued. April 3rd, journalists filed a $10 million federal lawsuit against her, ranking member, yada, yada, yada. Background of the claim. Okay, well, Taibbi's article references the Exile, a Moscow-based... Oh, yeah, here we go. The article references Taibbi's time at the Exile, a Moscow-based newspaper he co-edited in the late 90s, a 2000 book, The Exile, Sex, Drugs, and Whatever, co-authored by Mark Ames with him, contains satirical passages about sexual harassment that Taibbi says were fictional. He denied any misconduct, and no woman has ever formally accused him of harassment. Taibbi apologized in 2017 for the cruel and misogynistic language. Oh, that was your mistake, Taibbi. Never apologize if you didn't do something wrong. Apologize for cruel and misogynistic language. Sissy. I'm joking. I'd say that to him now anyhow. Taibbi, Taibbi, a GOP witness on government censorship, so this wasn't the Twitter files, argues Camilla Ordover's remarks were defamatory, especially after she repeated them on social media, outside the protection of the hate of the speech and debate clause, seeking $10 million. Well, you know what happened? First of all, we know this now. I'm going to go back and see if I actually predicted it at the time. I don't think I made any predictions about his chances of success. We know from the Elizabeth Warren, Deborah Holland, Nicholas Sandman, Covington Kids defamation case that it's not just in Congress, in debate, for which you get immunity under the Westfall Act. The Covington kids lawsuit against Deborah Haaland and Elizabeth Warren, as relates to tweets that are still up, was dismissed under the Westfall Act, which is basically immunity for federal workers unless the state waives the immunity and allows the suit to go forward. So Matt Taibbi had sued, and this morning he took to Twitter to post an update that he got on a letter bearing the letterhead of Alina Habba that says, Dear U.S. Attorney Alina Habba, thank you for the letter I received last night. Pictured below on your letterhead, we've replied, will the assistant United States Attorney Basiak separately, sincerely, Matt Taibbi. Now, some people who either don't read the letter or don't get that he's being sarcastic may not get that he's being sarcastic, but this is the letter that he got from these United States of America. And the problem is, it's going to piss everybody off. It's an injustice, but it's a lawful injustice under the laws as they currently exist and how they've currently been interpreted. So this is Taibbi versus Camilla Ordover. She's a Democrat, and now you have the bar looking after the members of the bar, everybody, because every politician wants to be able to freely defame, even if they're the victims of it. And so whether or not there's an inherent conflict of interest for the administration to hold Camilla Ordover responsible when it might be used against other Republican politicians later. Judge Payton, this is coming from Alina Habba, but it's signed by Alina Habba, by John Basiak, Assistant United States Attorney. All right, here we go. And it says that the office represents a defendant, United States, improperly pleaded as Sidney Kamlager in the above referenced matter stemming from allegedly defamatory statements. We write to request pre-motion conference in accordance with your honor's individual preferences. We anticipate filing a motion to dismiss for lack of subject matter jurisdiction under Rule 12b-1. That's the general motion to dismiss, failure to state a claim, or lack of jurisdiction. I think 12b-2 is failure to state a claim. 12b-1 is lack of jurisdiction. For two reasons. Plaintiff failed to exhaust his administrative remedies under the Federal Tort Claims Act. And two, his claims are barred by the intentional tort exception of the FTCA, Federal Tort Claims Act. Thus, the court should dismiss the amended complaint. We don't need to do the background. The Federal Tort Claims Act is the exclusive remedy for, quote, injury or loss of property, yada, yada, yada. The FTCA provides a mechanism for the United States to substitute itself as defendant for employees sued individually, which I feel that they've done here, as relevant here upon certification by the Attorney General or her designee that the defendant employee was acting within the scope of his employment or employment at the time, shall be deemed an action against the United States. So they've taken up the defense here for and on behalf of the employee. The FTCA applies here because plaintiff alleges that he suffered personal injuries from statements made by Congresswoman Camilla Ordover during a congressional hearing and republished on social media. In other words, she's an employee of the state. Court lacks jurisdiction. The court lacks jurisdiction over plaintiff's defamation claim under the Federal Tort Claims Act for two reasons. He failed to exhaust his administrative remedies. And second, the claim is barred under the FTCA's. See, what drives me nuts is I don't know if this is the nudge so that Taibbi, goes through with the proper procedure so that they can then compensate him and just make him do it according to the letter of the law. It sounds here they're going to say, sorry, Westfall Act precludes you from even being able to sue employees in the first place because we haven't waived sovereign immunity. To invoke the FTCA's limited waiver of sovereign immunity, a plaintiff prior to the filing of the suit must present a claim to the appropriate federal agency, and the appropriate federal agency must either deny the claim in writing or not act for the period of 6 months. Accordingly, courts lack subject matter jurisdiction where the plaintiff institutes an action before exhausting administrative remedies. The requirement are jurisdictional, cannot be waived, yada, yada, yada. Now, I'm wondering if he's going to be time barred if he goes back to try to go through those procedural remedies. I'll have to pick Barnes's brain about that on Sunday night because at the end of the day, I'm just a former Quebec civil attorney. I've done my best to learn the laws of the land through the last 7 years of legal political analysis and commentary. But here, plaintiff does not allege that he submitted an administrative tort claim. The House of Representatives has no record of such a claim. The way second, even if plaintiff had fulfilled it, the court still lacks subject matter jurisdiction because the United States has not waived sovereign immunity for defamation claims, nor do they want to, it would seem. Although maybe, as Barnes said during the Elizabeth Warren, Deborah Haaland case, maybe this will be the public outcry for the government to, they didn't like presidential immunity. They didn't like presidential immunity because of the power that it would give to the president to literally assassinate his political rival. Horse shit. That was never a proper interpretation. If they didn't like presidential immunity, they should presumably also not like as much federal employee immunity. Defamation suits against the United States are prohibited under the section. Thus, the court should dismiss the plaintiff's amended complaint. And then you have the delay here. So Matt Taibbi is learning that, he may or may not have followed the proper procedure to begin with. But even if he had, they didn't waive sovereign immunity as relates to defamation claims, nor apparently do they want to, because that is a weapon that they like to have at their disposal, or at the very least, a shield that they like to have at their disposal. Although maybe if the public outcry is adequate, sufficient, and loud enough, maybe they'll say, we were ready to strip the president of presidential immunity. Let's talk about not protecting employees with federal employee immunity. Certainly not when they are acting beyond the scope of their duties, and certainly potentially even when acting within their duties, quote unquote, when they're doing it maliciously for the purposes of exploiting their immunity to overtly, deliberately, and maliciously defame a citizen.